Yes.
Mrs. Harrison, I believe you've been told, but owing to an event at lunchtime,
Yes.
We will be rising at 5:01
Yes, of course.
and not resuming until 2:15.
Yes.
If, which the board hopes, we are able to finish the case today,
Yes.
we would be prepared to sit a little bit after 4 o'clock in order so to do. Thought I'd just make that clear at the outset, but of course we do have tomorrow
Yes.
if necessary.
Yes. Well, I'm very much obliged, my lady. May it please my lady, my lords, in this matter I appear on behalf of the Bermuda Hospital Board with my learned friend Mr. Bashadsky, and Mr. Benjamin Brown, QC, and Mr. Krish Lanin appear on behalf of the plaintiff. My lady, my lords, there are two other people I ought to introduce. The first is Mr. Alan Doughty from the Bermuda Bar, who appeared at trial and in the Court of Appeal of Bermuda, and he sits behind me on the far left. And also Mr. Kamal Williams, who I'm pleased to say is in good health, and he has travelled from Bermuda for the hearing of this appeal.
Well, they're both very welcome,
I'm very grateful, my lady.
and I hope they recognise the flag that we're flying.
We were rather hoping that was going to be there, my lady.
Yes, we always fly the flag of the country from which the appeal comes to demonstrate that we are not the Supreme Court of the United Kingdom.
Yes.
We are the final court of appeal for that country.
Yes, yes. My lady, the framework that I propose with the board's permission to address is, first of all, is material contribution to injury an exception or an application of the but-for test? If it is an exception, what are the conditions and limits of that exception? Thirdly, policy issues in the field of clinical negligence. Fourthly, the facts relating to this appeal, if or insofar as they may vary from those in the agreed statement of facts, and the committee will have seen the way that the plaintiffs have put their case. And fifthly, and finally, if and insofar as relevant, comparative law, briefly.
I wonder whether it might be helpful to begin with the facts, because that will then help to focus the legal arguments.
Well, certainly, my lord, although the primary facts are not in dispute, it's a question of delayed management of appendicectomy.
Yes, well, if they're not in dispute, can we just run through and identify that we know clearly what they are?
Certainly.
Here, Mr. Williams arrived at 11:17.
Yes. There is a chronology,
Yes.
my lord, in the back of the agreed statement of facts, if I find the right page number. 15. 50, thank you very much.
He was seen by Dr. Okereke at 11:44.
Yes.
And he was seen again by Dr. Okereke at around 12:17. I think we get that from a nursing note at page 343. I couldn't find any notes of Dr. Okereke himself.
There may not have been a note of...
He made his written statement on the basis of something.
Yes.
And in his written statement, he does refer to visiting Mr. Williams at that time. That's his paragraph 5, his statement at page 330.
Yes.
And he was not required to attend for cross-examination, was he?
It's my understanding that he wasn't.
No, correct. So we got his undisputed evidence that he saw Mr. Williams at 12:17. Now, he said in his witness statement, and there was no challenge to this, that he ordered a CT scan about an hour after Mr. Williams' arrival in the emergency department, which would coincide with his examination at 12:17 after he'd been given some painkillers to enable a proper external examination to be made.
My lord, yes. Save that. There are two other references, and I'll get the page numbers, to the CT scan finding being requested at 1310.
Yeah. Now that's indeed how the judge proceeded and the Court of Appeal proceeded. I suspect it probably doesn't matter at the end of the day, because the claimant's expert, Dr. Lightman, gave evidence that it was reasonable to order the scan at the time when Dr. Okereke said he ordered it. That's to say, within an hour of arrival in the emergency department.
Yes.
The Court of Appeal, no criticism was made of Dr. Okereke by the claimant on the basis that he did what he said he did, ordered a CT scan at around the time of his 1217 examination. The Court of Appeal approached it on the different basis that the CT scan wasn't ordered for another hour, and they were critical of the delay then.
Yes.
But I say it may not matter, because on the footing that Dr. Okereke recognised a need for a scan at the time of that examination, whether he actually ordered it when he said he did, and the delay was administrative, or whether he failed to order it for another hour.
Precisely.
Really doesn't matter either way. Either way, that's a period of culpable delay, isn't it?
Well, my lord, it may be, but the question is whether or not that culpable delay, even if it were culpable, makes any difference to causation. In order to make any difference, we respectfully submit, to causation, the surgery should have taken place before the rupture occurred.
Yes. Well, I think we're at the moment, I think it'd be helpful to sort out what the facts are, and then you present the argument. Either the Court of Appeal was right in treating it as 117, and the hour between him saying he ordered it and it apparently being ordered is unaccounted for, or he ordered it at 1217 when he said he did.
Well, my lord, that's true, but of course the judge didn't hear from Dr. Okereke.
No, that's because his witness statement saying that he ordered it an hour after the arrival in the emergency department was not challenged, because the claimant was content that the case should proceed on that basis.
Yes, and indeed, their case was for a very substantially earlier surgical management than in fact occurred.
Well, now that was really based on Dr. Lightman's evidence, because he then went through, did he not, what ought to have happened following the ordering of the CT scan. He said it would take about an hour to an hour and a quarter for the administration of the contrast fluid and for it to work its way through down to the appendix.
Yes.
And then he said you'd allow an extra 15, maybe 30 minutes for interpretation and report back.
Yes.
Allowing, therefore, about a couple of hours from ordering the CT scan to getting results.
Yes.
Am I right in thinking he wasn't cross-examined in any detail on those matters?
The person who was doing that, I don't recall that from the transcript that is available.
Nobody suggested to him, so far as I could see from the transcript, that allowing an hour and a quarter for the administration of the contrast fluid and half an hour for the interpretation report was an unreasonable suggestion.
Well, certainly the board's case that was run was as per Dr. Conn, namely that the rupture had already occurred and that the management... So it was a completely different case.
Dr. Conn's evidence, written evidence, was largely based on statistical exercises. He doesn't appear to me to have condescended much into the detail of, well, was an hour and a quarter a reasonable time for the contrast fluid? He presented his case rather differently.
Yes.
So if we've got the CT scan either being ordered 1 hour after arrival in hospital, or 2 hours after with an unaccountable delay of 1 hour, and 2 hours for the result to be reached, you would, on that scenario, have expected to have a result 3 hours from arrival, or 4 hours from arrival with an unexplained hour's delay.
Subject, of course, to the evidence about the CT department being extremely busy that day. And again, the detail of whether that was put to Dr. Lightman and whether that would have made a difference to his timings.
But
it's not clear from the transcript.
As I understand the findings, shouldn't have made a difference if there had been ordered an instant CT scan. As it was, it just sat in the general pile waiting to be attended to.
Yes, instant is a flexible concept.
Immediate. Right.
Yes, a stat, yes.
So then you've got a period of time after the CT scan should have been reported for surgery. And Dr. Lightman suggested an hour. I don't think there was any evidence about the state of the theatre in the hospital that day, was there?
I don't recall that there was, but my recollection is that he didn't criticise the period of delay between, as elapsed time, not culpable, between the reporting of the CT scan and being in theatre, which is approximately 2 hours.
So you got, on that scenario of events, you'd have a period of 4 to 5 hours. At the upper extreme, I suppose, 6 hours from arrival in hospital. Now, is that a fair understanding of the raw evidence?
Well, it's a reinterpretation, certainly, of the judge's findings, but in terms of such evidence, will you, my Lord, forgive me for a moment? Yes.
Then, just looking to see what's common ground, there's no dispute, is there, that the delay increased the sepsis?
Yes.
Right. And there are some very minor differences between Dr. Lightman and Dr. Conn about, for example, the nature of the cardiac episode.
Yes.
But there doesn't appear to be any dispute that sequelae of the sepsis were cardiac ischemia,
Yes.
some sort of heart episode,
Yes.
and a period of being severely unwell.
Yes.
So, well, that's very helpful. So there's no dispute that the sepsis caused the sequelae, and there's no dispute that the delayed treatment caused or materially contributed to the quantity of sepsis.
There is no doubt, my Lord. Sorry, but perhaps I should correct the second point. There are two factors in the events in theatre. One is the surgery and the strain and stress of surgery, which was unavoidable.
Yeah.
The other is the septic load. And I accept, as I obviously must, that the septic load would have increased over the period from rupture to surgery.
Right.
What we don't know, and there is no evidence, and there was no exploration of this in the evidence, and no exploration of the literature in the bundle with respect to causation, there is no evidence about whether there is an analogue or an exponential relationship between morbidity risks and period from rupture to surgery. So, for example, in our submission, it is highly unlikely that you would be able, on any analysis of literature, and this wasn't done, it wasn't before the court, to show that there was any difference arising from a particular period, 2 hours or 4 hours or 6 hours post-rupture, as opposed to the difference between pre-rupture. So pre-rupture, I completely accept, it would have been probably an uncomplicated appendectomy.
Yes.
But from the moment of rupture, you have a complicating factor, and the delay thereafter, in my submission, it would not be possible to establish, certainly on a balance of probabilities, that delay, once rupture had occurred, of the order we're talking about here, would have made any difference at all.
When you talk about moment of rupture, I think the evidence is there isn't a moment of rupture, it's a progressive
Well, yes, it's a tearing as opposed to a balloon explosion. But that said, clearly it tore because it was under pressure. So there would have been an expulsion of fluid into the... But we are, to an extent, I'm afraid, my lord, speculating on the process, and that's part of the problem.
Yes, well, I think it's helpful, at least from my point of view, helpful to have elicited which of those facts, if any, were in serious dispute before now looking at the legal arguments you present.
I'm sure I will be corrected if I've got anything wrong, but my lord, certainly that's my understanding of the factual issues. My lords, we respectfully agree with the interveners when they say that the law in this area is, and I quote, profoundly intellectually unsatisfactory, incoherent and confusing. That's their paragraph 43 at page 19 of the intervention. Respectfully, we agree, and we add that it's near impossible for practitioners to advise with any certainty or clarity about causation in clinical cases. It was very different after Gregg and Scott, because there you knew that if the chance of if the delay had made no difference in the sense of your long-term survival rate was always above 50%, then you had no claim. If it was always below 50%, you had no claim. It was only if you went between above 50 to below 50 that you had a claim. And the beauty of that, as with the but-for test generally, is that it splits moral luck. It splits the risk equally between the claimant and the defendant. Now, my lords, what we have now is a position whereby the patient, the person stuck at the back of the bus in the case of Lee in the Southwest ambulance, was stuck unavoidably in a collision, trapped with a serious knee injury at the back of a bus for a total period of 50 minutes, of which the last 17 were guilty delay because of the delayed arrival of the ambulance, and yet she recovered 100%. Our submission is that that is an absurd result. It is arrived at because the court applies material contribution to injury as defined by Bailey, arising from Bonington, and whereas if material contribution to injury is not an exception to but-for causation, that claim in our submission would probably have failed.
Well, but coming back to the facts of this case, there's, from what we've already discussed, there's no dispute that there was a material contribution to the sepsis, which is a form of harm. It was actually worse than it would otherwise be. That could be postulated on a but-for test.
But that, with respect, is falling into the same trap as in the cancer cases.
Well, maybe the right starting point is to identify, was there any actual physical harm done?
Well, with respect, my lord, our submission is that the difference is between contribution to outcome as opposed to contribution to process. So in Bailey, the judge found that there was a contribution to the weakness, and that the weakness resulted in the cardiac arrest, or the aspiration of vomit and the cardiac arrest. Whereas the question we submit is, did the weakness make a contribution to the outcome? And if you can't show that on a balance of probabilities, then you shouldn't be able to succeed. And so in this case, pre-rupture I accept. If surgery should non-negligently have taken place pre-rupture, then I would accept it would have been on balance of probabilities an uncomplicated appendectomy. Post-rupture, at any point in my submission, you can't say that, because the evidence isn't there. It certainly isn't there in the bundle and wasn't explored in that way. So you then have a position that you might have as a matter of fact, a contribution to a physical, pathological process which is relevant to the outcome, but it doesn't get you any further than that. So, for example, in the case of Tahir, and for the note, that's volume 5, tab 52, pages 1729 to 30. There was a spinal abscess in a 13-year-old boy developing over New Year's Eve. And his case was a 24-hour delay between when diagnosis should have been made and surgery actually being performed. And the judge said, no, the delay was approximately 2 or 3 hours, and awarded pro rata damages for what the whole of the injury would have been worth. And the Court of Appeal in Tahir said in terms that you have to prove that the delay has made a measurable difference. I don't know whether we would like to look at that report now, but certainly that's the page reference. And there are 5 propositions of law set out by Lord Justice Otten.
Could you give me the page reference again?
1729, my lady.
Thank you very much.
Tahir and Haringey Health Authority.
Right, did you say 1729?
I did, my lord, yes. It's tab 52 of bundle 5.
1729 is not to here.
No.
26. 1726,
1726 is where it starts, and 1729 is the relevant citation. I beg
No,
your
I'm
pardon.
afraid not.
That's not the electronic citation. 1729 is the paper number, but
I need
seems
the
to be a difference
electronic number.
between the electronic bundle number and the other.
I'm so sorry, my lady. I thought they were the same.
Wait a minute. Well, there should be.
Yes,
They're
well,
supposed to be, but it doesn't always happen.
2655 is suggested, my lady. I don't know whether that's right.
2655. No. That's
I'm so
Thompson
sorry,
and
that's-
Smith Shipbuilding.
Wait a minute.
that's the next case, if that's any help.
Tar here. Try
140.
140?
2630.
2630. Well done. 26. Now, somebody better start working hard
Yes.
to find the electronic page references to everything that you want to draw our attention to. Because speaking for myself, I only use the computer.
Yes.
Use
The frustration is immense. I'm so sorry.
It's going to be very roughly 900 pages difference, I'm afraid.
Thank you, my lord.
That's a lot of help, isn't it?
Yeah.
So there should be a consistent...
I think it's 904 pages.
Yes.
Thank you very much, my lord.
So your learned junior can swiftly do some
Yes. We bring our calculator.
calculations. Yeah.
Yes.
Anyway.
Good. Well, let's go back to time.
The propositions from Tahir, internal page, looks like 107. Copying's poor. The right-hand column,
This is an awful copy.
yes, the electronic obviously isn't any better. Okay, thanks.
33, it should be.
I start with the following propositions of law, if the board has that. The burden of proving causation is upon the plaintiff. No. Causation is a question of past fact. If he proves negligence as the sole or a substantial cause, or that it materially contributed to the damage, he will succeed in full. If he fails to cross the threshold, then he fails to recover any damage. Barnett. Plaintiff can't recover damages for the loss of a chance of a complete or better recovery. Hotson's relied upon, but of course now also Gregg and Scott. Hence, the plaintiff does not seek to prove the loss of a chance. Here, the plaintiff doesn't seek to prove the loss of a chance. His case is that because of the delay, he's worse off. Or had it not been for the delay, he would have been better off. It's not sufficient to show that delay materially increases the risk, or that delay can cause injury. The plaintiff has to go further and prove that damage was actually caused.
Now,
That-
he says he does that because he says this wasn't merely an increase of risk, there was an increase of damage in the form of the sepsis, and the sequelae were consequences of that sepsis, to which the damage caused by the
Well,
lateness was a material factor.
well, with respect, he didn't sue for the sepsis. He sued for the consequences that occurred in surgery.
But the sepsis is the link. It's part of the causative mechanism.
Well, this is the, forgive me, the same issue as arose in Bailey, namely that a contribution to, in some non-causally relevant, as in non-causally relevant to the outcome, manner, is equated with being causally relevant to the outcome. And we submit that's wrong as a matter of law. You need to be able to prove causation of the injury for which you're suing. So merely proving that there was a bit more sepsis doesn't help you unless, per Tahir and Gregg and Scott, unless you can show that it was that delay and that actually resulted in the injury occurring.
On that basis, he's got to show that it wouldn't have happened otherwise.
Exactly, my lord. At the point at which the breach occurs, he has to show that it wouldn't have happened. And that's classic orthodox causation.
Well, I wonder.
Well, this is why we're here, my lord.
Yeah.
This is precisely why we're here.
So where does material contribution come in?
Well, we say that it is an application of but for and not an exception to it. And we say that with respect on a good judicial authority, which I can take the board to. But if it is correct, if we are right that it's an application of it, then you have to show either that the breach caused part of a divisible injury,
Of a divisible
injury. So you either cause part of a divisible injury, which is exactly what Bonington did, or you prove that it was a necessary cause of an indivisible injury. So a part cause, one of a number of causes of an indivisible injury. What is not legitimate, in our submission, is to use material contribution to injury as a synonym for causal uncertainty. And that is exactly how it is being used.
But you accept, do you, that if your negligence is one of a number of causes of an indivisible injury,
Yes,
then you're liable.
absolutely. That's
And if the result is that you're the only person liable and you end up paying 100%, well, then that's one of life's little problems.
absolutely. That's exactly, because that's the equal sharing of moral luck.
Yes.
Sometimes defendants pay for more than they're truly responsible for. Sometimes they don't.
Yeah.
But in order to have that outcome, you need to have the 50% test.
Sorry, you need to have
You
what?
need to have the balance of probabilities test in order for that outcome to be there. So the old cases, my lords, which I can summarise in a nutshell, but the pre-Bonington cases, which were referred to in Bonington as establishing that material contribution to injury was a long-standing proposition, those old cases were all but for causes. They were all cases that involved more than one factor being a but-for feature of the accident. They were either railway cases or cages falling down mine shafts or employees scraping rollers at the end of conveyor belts and usually being killed or seriously injured. And in all of those old cases, they refer to material contribution, but they refer to it to describe multiple cause cases.
And you say, do you, that of Bonington what? That inherent in it is a finding that the injury wouldn't have occurred but for the whichever of the hammers it was that was negligent.
Yes, exactly. Well, because the thing about Bonington is that the House decided, and everybody since then has agreed with this analysis, that every single particle of silica dust that was inhaled was causative of injury. Because it is a cumulative process.
What's wrong with saying every part of the sepsis was a cause of the injury?
Well, the problem with that is the syringe example from Professor Stapleton. A nurse administers a drug properly prescribed to a patient. She negligently prescribes too much, administers too much. But in fact, the patient dies not because of the surplus of the drug, but because she was allergic to the drug.
Yes.
And so, although the negligence made no difference.
So she'd have died anyway.
Exactly.
Yes.
It's a Barnett situation. And the same is the point here, that at the point that the negligence starts, you have to examine, would the patient have suffered the outcome in any event, on the balance of probabilities? And that's absolutely orthodox causation. If you don't, you end up in the position which we are respectfully in now, which the House sought to avoid in Gregg and Scott, which is that heads I win, or heads you pay me everything, tails you pay me something. Because effectively now, the only way a defendant can succeed is if the defendant can prove, on the balance of probabilities, that their breach did not cause the injury. Because the way the law is at the present, if the claimant can discharge but for, then of course the claimant succeeds.
In Professor Stapleton's example, if the nurse administers a toxic dose, but the defendant say she would have died anyway, who has to establish that she would have died anyway?
Well, that would be, the burden is on the claimant, plaintiff in this case, of course, to prove causation.
She does that by saying you administered a toxic dose.
Yes. Well, there's some discussion in some of the books of the authorities about raising an evidential burden, effectively, that the defendant would then have to say, well, you were allergic to this, and so therefore that would have happened in any event. So look at the Barnett case, for example. It's not a legal onus, but perhaps an evidential onus. Now, in other words, the parties in practice have to provide the better explanation for the outcome, whatever that might be, whatever the context. So to take that example, if the defendant asserted that the patient was toxic to the drug but adduced no evidence, then there would be no basis upon which the court could find it.
Yes, I mean, evidential burden is sometimes a convenient expression, I grant you, but it's exceedingly misleading, isn't it?
Yes.
The bottom line is that you can't have any findings without some evidence.
Yes, absolutely. And our submission is that in clinical cases, unlike almost all other cases, the defendant is frequently not in a better position than the claimant to adduce any evidence at all relating to that. I say that because, obviously, in factual terms, they could call the surgeon who said, I did this, that, or the other at the operation. They could call the administrator to say how many nurses or consultants were on duty, or whether a liver transplant was available. So they could call evidence of that kind of thing. But what they can't do is they can't call evidence about how much developing sepsis do you need after rupture before the balance is tipped. And why can't they? Because they're in the same position of causal uncertainty as the claimant. Nobody knows. The answer why nobody knows is because, by definition, something has gone wrong. It's unethical to do that kind of research on patients, so you're thrown back to biological basics. So the cancer cases, we will probably have to come back to that. But in the Fernicite case, Jones and the Environment Agency, Mrs. Justice Swift had to decide a series of cancer cases, bladder cancer and lung cancer cases. And the claimant's argument in that case was, well, the occupational exposure had materially contributed to the cancers. And the evidence was very closely analysed, and it boiled down to this, that there were so many different factors involved, some relevant to the patient, some environmental, some genetic, some occupational, but it was impossible to do anything more than express it in terms of likelihood. In other words, you have to examine what data there is and draw whatever epidemiological conclusions you can from that. And so, in that case, she applied the doubling of the risk test because she said that was the only basis upon which she could make any findings. Whereas, if my Lord's example is correct about any contribution to sepsis is enough, then Jones would be wrong, because as long as you can prove that you have put a risk into the pot, then you scoop the damages. And we say that's not the law.
How far off your track are you, in fact? You've been a bit distracted, I'm afraid.
Well, my lady, I'm in the board's hands.
No, you're not. You stand there and try and tell us what you want us to do. And we'll interrupt you from time to time.
Yes, certainly. It would probably be helpful, because the principal legal issue is it an exception or not, it would probably be helpful to look and see where that comes from. In other words, what the judicial basis is of that. Because if it is built on sand, as we respectfully submit it is, then you're thrown back to orthodox causation. So, the starting point for that is Lord Roger's judgment in Fairchild, which is volume 2, tab 19. 1210, I'm told. My lords. Thank you. The next one is going to be Sinkovich Phillips.
Sorry, what was the number you gave us?
1210, my lady.
Afraid not.
Absolutely.
904, my lady, to be 1354, I think, possibly.
On that hypothesis, that would be great.
My Lord, what you suggested, that was the answer, the number one had to add.
Talking about the Fairchild exception.
Yes, doubling of the risk.
Not that.
I don't know what
I'm so sorry about the
I
numbering.
mean, this is an impossible way to conduct a hearing.
Well, it is absolutely impossible, and I was under the apprehension they were the same, and I'm very sorry they're not.
Wait a minute, we can do this. Tab 19.
An index to the authorities. It's 219, but that's not helping us.
Fairchild starts at 832, just to make life easy.
The trouble is that the page numbering, the paper page numbering isn't entirely sequential. There are quite a large number of pages inserted in.
Child itself, yes, absolutely.
And that'll mean for different parts of the bundle the number to add on will differ.
This is not the way that appeals should be prepared before the board,
I
I'm
know,
afraid.
lady, and I can't apologise enough.
Somebody had better go through and make sure they have found the electronic reference to every case you intend to refer to.
Well, I wonder, I'm very conscious of time, but...
Yes, and if you run out of time, that's, I'm afraid,
Yes.
the fault of those instructing you.
Well, yes. My lady,
We'll do our best.
Thank you very much. Lady, do you have...
You want Lord Roger, don't you?
Yes, please.
Well, around 899.
Yes. I have it at paragraphs 128 to 129.
That is 899.
That is, yes, well done. 120.
Which internal pages 99 to 100. So, at page 129, he expresses the conclusion. Ward law became a convenient point of reference. This is just below letter B, paragraph 129, which indeed it has. In such cases, basis of liability is of considerable importance. And he asserts it's enough if the defendant's wrongful act materially contributed to the claimant's injury. The law is not applying but-for test of causation. In Ward law, the pursuer did not need to prove that but for the dust from the swing hammers, he would not have developed pneumoconiosis. All he needed to prove was the dust from the swing hammers contributed materially to the dusty atmosphere which he breathed and caused his illness. The cases upon which he relies for that proposition are set out in paragraph 128 on the preceding page, and they are Senior and Ward, and Wakelin and London and the South Western Railway Company. But, my lords, those cases were both but for. Clearly but for. The Senior and Ward was the miner who died because he knew that the system for checking the rope was never or rarely used, and he should have checked it himself, as was the requirement, but he didn't, and he got in it, and of course the defect caused him to fall. So both were operative.
It's a contributory negligence decision, isn't it?
The old cases are, my lord, yes, before
Yes.
the 45 or 48 Act,
At
yes.
the stage, presumably, when it was a complete bar.
Yes.
Yes.
And some of the old cases do, but they do specifically refer to material
Yes, they
and
do.
materially contributing, not just in the context of defence of of contributory negligence.
Yeah.
But on the facts, all of the old cases, and there are a number, all of them are but-for cases, all of them. And certainly those two are. Wakelin was...
In paragraph 129, where he draws the distinction between the but-for test and the other tests, what is he talking about there?
Well, he's talking about Bonington, and what he is saying is that Bonington decided that you don't need to prove contribution to damage on a but-for basis. But in fact...
That's what he's saying, but you're saying that's not right.
Absolutely. My lady, we say it's not right
This
from
is,
an
the Lord
analysis...
Roger, this is the Lord Roger wrong point.
Well, the board may believe it is. We certainly say that it is not right as a matter of law, is what we submitted. And
It is not right because?
It's not a correct proposition of law because Bonington itself decided that each particle of silica dust was causative. They knew it was, and one only needs to read the judgment of Lord Reed in Bonington to see that. The novelty of Bonington was of holding the defenders liable for a portion of the disease which they knew, on a balance of probabilities, they had not caused. That was the novelty of Bonington. But the point about apportionment was never argued and never taken.
Apportionment was never argued, was it?
Not in Bonington. No.
Hence the difficulties that we got into in Barcroft Wars.
Well, yes, exactly. So apportionment was never raised, nor was it raised in McGee. But McGee was a different case, but Bonington is what's often regarded as the starting point for MCI, material contribution to injury.
Why do you say that Senior and Ward was a but-for test? The defendant's negligence was failing to check the cable. Is that right?
Yes, they had
What was the plaintiff's negligence?
The system was that the mine operators were supposed to examine the cable at the end of a shift every night.
Sure.
And the workers were all supposed to examine it in the morning before they got into it.
Yes.
That was the system. So it wouldn't have happened but for the failure.
Because his negligence came second, you say?
Well, yes, each was a negligent cause, and each was a necessary cause. Their failure to check it meant that the frayed rope was still on the cage. His failure to check it meant it was still on the cage. It's a multiple cause case.
Precisely.
But each was
I think right that each has to be a necessary cause. I'm thinking of bad quite in cases, but Siemens Nixdorf, where the case there was that the premises were being built in London with all sorts of devices to protect against flooding. So there were multiple defences. No single failure of one defence system would have caused any harm unless other ones have been non-operative too. And the defendants argue, well, look, you can't prove that your negligence was a necessary cause. Court said, well, you then reach the odd position that the more people there are responsible, the less anybody can be held responsible.
Absolutely, my lord, that's a Cook and Lewis position. If it's a multiple tortfeasor case, that's easy with respect, because then you simply say, well, we know that this wouldn't have happened but for the negligence of, in the Cook and Lewis case, the two hunters shooting into the forest. Has to be one of them, can't prove which, so they're both liable. It's the same kind of situation. And here, had there been delay at the GPs and then delay at the hospital, it's right in the Cambridge Medical Group, then both would have been liable because it wouldn't have, the complications wouldn't have arisen but for the negligence of each defendant. But in this case it's different because it's natural causes. I don't know whether that answers my lord's question. So the assertion in Fairchild by Lord Roger...
Why should it make any difference that it's natural causes? Just that that makes the defendant wholly liable. Natural causes aren't liable.
No, the natural causes argument is the moral luck. Because if you are able to succeed only by proving a minor contribution to a process but no contribution to the outcome, then you're going to be recovering in almost every clinical negligence case, except where the defendant can prove but for...
I understand that, speaking only for myself. What I don't at the moment follow is why, if you prove the material contribution to the process, the judge isn't entitled to infer a material contribution to the outcome.
Well, because the two may be completely different. It depends what
They
the
might be, in this case.
Well, it depends what the evidence is, my lord, and in this case the evidence wasn't explored. For example, there is evidence in
So it
one...
boils down to a burden of proof point.
Yes, a burden and standard, yes. Yes.
Well, we know what the standard is.
Yes. But yes, it is.
I see. Thank you.
So with respect, we said that's probably the start of the hare. Lord Phillips in Sinkovich picks this up. I have that at 2320, which is my volume 7. It's the core bundle. I hope that's the same.
What tab is it?
Tab 8, my lord. Paragraph 17 of the judgment in Sinkovich. Do we have the actual page?
2410.
2410.
Yeah, sorry, you're right.
Oh,
Well, that's the beginning of Sinkovich, it's 2410, yes.
You want 17, did you say?
paragraph 17, my lord, yes, please.
Yeah.
Yep. Well, that's it. Yeah.
Having set out at paragraph 16 the basic broad principle in the sharing of moral luck, he goes on at paragraph 17. There is an important exception to the but-for test. Where disease is caused by the cumulative effect of the inhalation of dust, part of which is attributable to breach of duty on the part of the defendant, and part of which involves no breach of duty, defendant will be liable on the ground that the breach has made a material contribution to the injury, to the disease, Bonington. The disease in that case was pneumoconiosis. Disease is divisible. Severity depends on quantity inhaled. And then he goes on to say, defendant didn't argue that he should only be liable for that, the extent to which he had contributed to the symptoms.
Does pneumoconiosis depend on the quantity of silica inhaled? I thought it was well understood that a single fragment would do.
Well,
That's true of mesothelioma. Well, it
Yes.
was thought to be, but pneumoconiosis is a
Not pneumoconiosis.
there's a dose
pneumoconiosis is a
effect.
cumulative, and every particle of silica accumulates and contributes to the damage.
Right.
So he there explains it as an exception to but for,
Yes.
albeit with a very narrow construction of its application, which, of course, if it is an exception, it should be clearly defined. Paragraph 24, though, he seems to interpret Bonington as a but for. He deals with McGee at first, and then halfway through paragraph 24, facts of McGee were not on all fours with those of Bonington. In Bonington, it was possible to say the inhalation of the silica attributable to breach had contributed to causing the pneumoconiosis. So that's a but for. It satisfies on the balance of probabilities, the guilty silica dust had contributed to the injury. So there's an inconsistency there. And two further references, my lords, please. Paragraph 90, which is a difficult paragraph.
You say 90 is wrong.
I say that it's...
The
you want-
other side will up on paragraph 90.
It's difficult, and it's difficult to apply,
But
but
difficult is a sort of...
well,
If you want to say it's wrong, you might just as well say it.
I say parts of it are right. The cumulative and simultaneous in causing the onset of the disease is right. The application of the doubling of the risk test and tortfeasor being liable for an indivisible disease may not be right unless you interpret material contribution to injury on a but-for basis.
I think I need you to say that again.
I'm very sorry. The first part of the sentence of the paragraph I have no difficulties with.
You don't like the doubling the risk test?
It has difficulties in its application, and I know my lady is very familiar with that. It's useful, evidentially, in some cases, but it is not a substitute for fact-finding.
Not a substitute for...
Fact-finding, my lord.
Yes.
So it's part of the factual material.
Yep.
What's meant by simultaneously in the first?
Well, this is what was happening in Bonington and what gave rise to the difficulty. The two particles, guilty and innocent, were being inhaled at exactly the same time, as in Nicholson. And we say, if it's an exception, that's one of the conditions that should apply. It must be consecutive, it must be concurrent, simultaneous. Because otherwise, you apply orthodox but-for causation at the point of the breach in consecutive cause cases.
Where do you get that from? Simply from I say simply, but from Lord Phillips at 90. Is it anywhere else?
Well, it's the facts of Bonington, and
Right.
we say it's in the case, our printed case, my lord, that we explain why we think it has to be temporally concurrent,
Yes.
because that's what gives rise to the evidential difficulty. Otherwise, you apply Hodson, test at the time of the breach, its balance of probabilities, performance cars in Abraham, which is effectively like shooting a dead body in the clinical negligence context, or Barnett. So orthodox causation, unless the causes, innocent and guilty, are mixed and are concurrent.
So if they're a week apart, these two alleged causes, and you
Yes.
can't tell what's what, then that makes all the difference. You've actually got to be taking the... Well, they aren't doing it at the same time, are they? They're doing it a second or so apart.
Well, no,
on the
not,
facts
not,
of
in
Sullivan.
not in Nicholson, no, because...
Well, maybe not in Nicholson, but what is the logic of that? I didn't see that really.
Well, the logic
I
is-
don't see the logic of a requirement of simultaneousness.
Well, with respect, we say that the logic arises from the difficulty of proof.
Yeah,
If-
there may be a difficulty of proof,
Yes.
even
Well-
if there's no.
No, the problem in McGee was that they knew dust caused dermatitis, but they couldn't show whether it was the dust from the kiln whilst he was at work or the dust abrading his clothes as he cycled home. Couldn't prove, but you could prove that it was the dust. And so they were not able, if concurrent wasn't a requirement, then McGee would have been able to succeed, but you couldn't because it was consecutive exposures.
I've written down, tell me if it's right, you can only apply the Bonington approach if the causes are simultaneous.
Yes.
Because only then do you have the evidential impossibility.
Yes.
Is that right?
Yes.
Otherwise, you say it's Hodson.
Otherwise, it's Hodson, Barnett, performance cars. In other words, you measure the state of the claimant at the time of the breach, and you ask the question, would this have happened anyway or not?
Hodson's a case, of course, in which the judge made positive findings about the state of the
Yes,
plaintiff at the time of the subsequent negligence.
absolutely. And on the claimant's
But
argument...
I'm afraid I don't understand why you can't have cases in which you have the evidential impossibility in the case of events which happen one after the other, sometimes quite close together.
Well, you do, but the difference in Bonington was that you knew that all of the dust was causative.
Yeah.
And the evidential difficulty related to which part of the disease had you caused. And nobody went there. But if all you have is concurrent causes to something unknown and unknowable, then you have causal uncertainty. You just don't know. And the question is, who bears the risk of that?
Yes, I see.
Final passage in Fairchild is
In Fairchild.
in Sinkovich, I beg your pardon, lady, is Lord Brown at paragraph 176.
So have you got a page for that?
It's internal page 68, if that helps.
Can't be page. Sorry, 24.
2472. 176, yes.
Paragraph 176, yes please.
Yeah.
Halfway down through the passage, paragraph 176, he says this, I have difficulty, however, in seeing this as a true exception to the but-for test. Although the claimant in Bonington, the case which first established the principle, recovered full damages for his condition, that appears to have been because defendants took no point on apportionment. In a series of subsequent such cases, damages have been apportioned, however broadly. So, I would respectfully submit that we're in good company in seeing it as not an exception to but for.
The trouble is that those who take a different view are also in good company.
Well, they may be, my lady, but the basis upon which they so find is not a solid foundation in our respectful submission when you look at the cases and you analyse them. And if they're right, it gets you into all sorts of difficulties. One only needs to mention the outcome of the Fairchild enclave to see the difficulties that the law gets into when you alter the but-for test. The final passage is from Lord Justice Waller in Bailey, which also in the core bundle authority. It may be 877. Bailey, tab 1, please.
You found it?
Oh, yeah. Read it before.
So we, on our electronic bundle, for some reason, my lady, we seem to have yet a different numbering.
3079.
Thank you very much.
Got it on 3079?
It's the end of the 2187.
No, this is the case you say is wrong, is that right?
We do, with respect, yes.
Because if it's right, you'd be in serious difficulty.
If it's right, all defendants or all clinical negligence cases throughout the world are in serious difficulties. Exactly.
This is the concluding words of Lord Justice Waller's judgment.
Just before there, my lord, actually, if we can go to the preceding page.
Paragraph, please.
Yes, paragraph, bottom of, end of paragraph 39. Where he
End of paragraph 39.
Yes, he refers to Bonington, describes the facts, and then says at letter A, my internal page 1068, it's important to be clear precisely what Wardlaw's case decided. Did it decide in cumulative cause cases inadequacy of medical science meant relative potency couldn't be established, or you have to establish a material contribution, or did a claimant still have to establish, but for the contribution, the injury would not have occurred? He refers to Lord Keith's speech in Wardlaw's case, but he doesn't refer to, well, he then at 41 says, use of word substantial seems to connote a higher causative potency than Lord Reed's. Word substantial also appeared in different cases. And he refers to Lord Simon of Glaisdale in his case. I'm not going to take the board to that, but that opinion of Lord Simon clearly states that there was a contribution to injury, and all of the subsequent analyses in our respectful submission of Bonington are that it was a clear but-for case. Then, at paragraph 43, he refers to Lord Roger in Fairchild's case.
So if Lord Roger's is wrong, he must be right.
Exactly. Lord Roger is accurately summarising the position. Well, we've already examined that, and with respect, we say he doesn't. And then, over at 45, refers to Hodson and to Gregg and Scott. But, my lords, what he does not do is he does not refer in Gregg and Scott to Lord Hoffman's judgment at opinion at paragraph 77. Or he does refer to that one, doesn't refer to paragraph 79 or 80, 84, 88 or 90, which refer to the significance of exceptions strengthening the purpose of the main rule. So if you're going to have an exception to a rule, it needs to be clearly principled, clearly defined, and for a very good and just reason. So he doesn't refer to other relevant passages of Lord Hoffman's opinion, nor does he refer to...
This is his opinion in what? In which case? In Gregg and Scott?
In Gregg and Scott. And the relevant paragraphs are 79, 80, 84, 88 and 90. Nor does he refer to my Lady Baroness Hale's judgment, opinion in Gregg at paragraph 203. He does rely on Lord Roger in Fairchild, but with respect, that's not a solid foundation. I'm very conscious of time, and I wonder if I might invite the board's attention to some of the academic criticisms of Bailey, but perhaps before I do that, we should just look at the paragraph 46.
Yes, I think so.
Yes, and
But that's the source of your difficulties.
it is. It's the final sentence. In a case where medical science cannot establish a probability that but for an act of negligence, the injury would not have happened, but can establish contribution of the negligent cause was more than negligible, but for is modified and the claimant will succeed. Which would have the effect, we would submit, of effectively reversing the burden and requiring defendants to prove on a balance of probabilities the injury would not have occurred. Because on this announced, irrespective of whether Bailey may or may not have been decided correctly on its facts, this statement of the test goes far beyond what Bonington truly is proposition for.
What does contribution mean in that? In paragraph 46?
That's a very good question, my lady. And of course, in Bonington, they described it as material anything more than de minimis. But that was the problem that Mrs. Justice Swift had to struggle with in the Furnacite case, was of all of these various carcinogenic factors, which are there, some avoidable, some guilty, what do I decide is material? 15%? 5%? And explicitly, for policy reasons, she said it would be quite wrong and unfair for a defendant who's only contributed a small proportion of carcinogenic burden to be responsible for the entirety of an indivisible injury. So that's the policy argument, and hence we have judgments like Lee in the ambulance service, where 17 minutes at the end of 40-odd minutes in agony trapped at the back of the bus was held to be enough to recover for the entirety of a psychiatric injury. And hence, in Bailey, a bit of weakness 10 days or so before the aspiration of vomit was sufficient to allow her to recover for the entirety of her brain damage. So, my lords, if the but-for test is not in fact modified, and we submit respectfully that it is not, then certainly this is not an accurate statement of the law. There are quite a number of volumes relating to in the academic bundles, and perhaps I can, without taking the court to them, just refer very briefly to what they say and why we rely upon them.
And the academic volume is volume...
It's volume 6.
Well, just give us your headlines.
Yes. Well, the criticisms of Bailey started when it was first reported. That's tab 59, that's the official law reporters. It's in the case, so I won't trouble the board with it now. You have Professor Green's extract at tab 63, which again explicitly and for good analytical reasons supports our analysis of but for being a requirement. You have the paper by Dame Janet Smith in the Journal of Personal Injury Litigation extrajudicially at tab 64. Makes the same point about Bonington being divisible injury, and that accords with her judgments in the Atomic Veterans in the Court of Appeal about it only applying to divisible injury cases. You have Professor Stapleton, Unnecessary Causes, article tab 66. In particular, my pages 2082 to 86. It's the probably well-known passage where she criticises Bailey, and again it's cited both by the litigation authority and by us in our case.
2082
to 86.
Thank you very much.
You also have, in similar vein, an article at tab 67 by Storch out of the Cambridge Law Journal. Makes the same kind of criticism. And at the new tab of volume 9, there is an article by Professor Bailey, ironically so called, called Causation in Negligence, What is a Material Contribution? That's at tab 3 of volume 9. And on my numbering, I'm afraid, well, internal pages 174 to 178. So, my lords, we respectfully submit that when you analyse Bonington itself, the cases pre-Bonington and the cases post-Bonington, in particular the Fairchild enclave of cases, where it's clear from all of the opinions in those cases that they believe that they are establishing a unique exception to but-for causation. And they do so explicitly for policy reasons, and they very, I was about to say clearly, but perhaps that's not the right word, but they certainly seek to delimit the conditions of application narrowly and repeatedly say there will be no extensions to it. Although, of course, recently it has been extended to lung cancer. Whether that will stand remains to be seen.
But the Fairchild line of thinking is not relied on against you here, is it?
It isn't.
It's
No.
positively disclaimed.
Yes, it is. So Fairchild is based on McGee, which is a pure risk case. You therefore are in contribution to injury territory, and we respectfully submit that to get to contribution to injury, you need to prove a contribution to the injury on a but-for basis. Otherwise, you're in Fairchild and risk. So, and those are our submissions on why it is not an exception, but a true application.
There's clearly an important issue of principle there, but in this particular case, does your argument depend on the assertion that the claim made by Mr. Williams was simply for the consequences of the operation and not for the sepsis itself? If his claim included a claim that he had suffered sepsis because of negligence, would not in those circumstances the question of whether or not the adverse consequence of the operation, the damages for adverse consequences of the operation, would that not simply be a matter of remoteness?
I'm hesitating because I'm thinking of the Simmons case on which my learned friend relies, which is a remoteness.
Yes, it's just I wondered because in this case the judge at first instance did award damages for pain and suffering.
Yes.
Now, must that not have been on the assumption that the claim wasn't simply for the consequences of the operation, that it was a claim for sepsis? I mean, it's not very well pleaded, but it's at page 6 of
yes,
the
I recall the plea.
record of appeal this resulted in moderate to severe reduction in his left ventricular systolic function, sepsis and pneumonia.
Yes.
Now,
Well,
the sepsis presumably wasn't the result of the operation, it was something...
it was the result of the rupture, which
The rupture.
occurred as a natural event.
Yes. It just strikes me that if the claim was simply for the result of the operation, the judge wouldn't have had any basis in awarding damages at all. If you're right.
The injury was not well pleaded with respect, that's correct, but it was clearly the outcome for which he was suing. Not least because on the basis of that was about $170,000 worth of medical treatment costs.
Sure.
And some lost earnings. So that was clearly the outcome for which, if he'd just been suing for a bit of sepsis, what would that translate into in terms of quantum? It would have been a little bit of pain and suffering, which is what the judge gave him for the delay between when he should have been in theatre and when he actually got into theatre, which is entirely conventional. My lord, we seem to be straying into the territory of, as was argued in Gregg and Scott, trying to claim that you can sue for the more cancer cells being distributed around your body for the period of delay. But the question is that really the gist of what the action is about in tort? And how do you measure that in terms of any recognised heads of damage or pain and suffering? In my submission, the answer is you can't. You can only look at what is actually sued for. And in this case, it was the only thing that could have been sued for was the intraoperative complications, but that doesn't stop the judge saying you had extra pain and suffering or more than you should have had because of delay. May I deal with some of the difficulties that arise if it's not an exception, and what we respectfully submit should be the threshold conditions if it is an exception to Part 4.
If it is or if it is not?
If it is an exception,
yes,
it needs to be
then the qualification
defined. And there are 4 in our paper. First is proven contribution to injury. They admit that. That's paragraph 83 of their case. And the issue relates to proof, how you prove it. I accept that. I don't think that they admit that that it is therefore not an exception, but it's not clear. The second condition is temporal concurrence.
This is simultaneous again.
Exactly. We're back to the Sinkovich example, and we're back to the arguments which I've already deployed, so I won't repeat myself on those. It may be that this isn't correct, and it's not something which the litigation authority, for example, have picked up in the intervention as a temporal concurrence, and there is a reference in the judgment in Thompson and Smith Shipbuilders, which is the industrial deafness case, which I'm sure my lord will remember, that to concurrent in effect. But it's not clear what is meant by that phrase, and it's not clear what is meant by that phrase in the judgment.
The idea of is concurrent and simultaneous is the same thing, is it?
Absolutely, yes.
And it means that at any particular any particular moment, you're breathing in dust in a dust case,
yes,
from the same source.
Yes.
It's limited to that very, very limited class of case.
Exactly as in.
And if you're doing it 1 week and
yes,
from one cause, and the next week from another cause,
yes,
you're on the wrong side of the line.
yes, exactly.
What's the logic of that?
The logic is that at the end of the first week, if the first week is innocent, at the end of the first week, you look and say, well, what's going to happen to this person? Are they going to develop the disease or not? You don't look at it at the end and say, has the innocent made a contribution? You measure it when the breach happens, which is Hodson. So you measure it at the time he fell out of the tree, or rather when he landed.
Well, you measure it first of all by identifying when the injury actually occurs, don't you? Or when the loss occurs, when the disease occurs.
In a disease case, yes, and that's one of the problems with mesothelioma. It's a long-tail disease, so you have to go back a very long way. But pneumoconiosis is a cumulative and continuous process throughout. Perhaps that's why the litigation authorities submit that if you're going to have material contribution to injury as an exception, it really ought to be limited to industrial disease cases, which is what they do submit as a matter of policy, because it's very difficult to apply in the clinical negligence context without running into pure causal uncertainty and effectively resolving the benefit of the doubt against the defendant. One of the claimant's points in response to concurrence is they say, well, it should be concurrent in effect. So the innocent sepsis, however much that was then built upon by the guilty sepsis that followed. And so you can still have material contribution by that way. But our submission to that is, well, that's false, because you need to measure it at the time the innocent stops and the guilty starts. And what would have happened on the balance of probabilities at that point? Because otherwise you're back to the Stapleton syringe and the nurse example. And you don't need material contribution to injury in any event, because a tortfeasor takes the victim as they find them. So if you'd only need a little more sepsis to tip them over the edge, you examine what the risks were, you examine the evidence. If you'd only need a little more and you gave them a little more, you're about for cause, you pick up the tab for the lot. So you don't need it, except when the causes are concurrent. That's our submission as a...
But why will you always... I mean, in Hodgson, as we remember, Justice Hodgson was able to make a finding about the likelihood of the necrosis before any negligence on the part of the hospital had occurred. That's right, isn't it?
Well,
he came to the conclusion that the chap was already going to get the necrosis.
yes.
More likely than
Yes.
not. So in that case, that was not only possible, but was done.
Yes.
Now, supposing it hadn't been possible to say,
Well, or suppose Mr. Gregg hadn't been able to identify the precise percentages. On the claimant's arguments, both of them would recover. And we say with respect, it's illogical to be in a position that you're better off not being able to prove the chances, because that amounts to saying the claimant always gets the benefit of the doubt. Once the defendant's breached, claimant always gets the benefit of the doubt. And that's a moral issue. Should the doctors be the insurers? And
I'm just wondering why it isn't simply a matter of proof, as you say, of inference.
well, it will depend upon the case.
Why can't the judge say, it seems to me as plain as a pikestaff that the additional sepsis was a cause of the complications?
Well, that wouldn't get you an answer to the question of, would it have happened anyway?
Would it have happened anyway? I see. You say you've got to be able to answer that question.
Absolutely. Otherwise, you're in pure territory of uncertainty.
The reason you can't answer that question is because the science is not available to enable you to do so.
Well, that's...
And obviously it may depend upon the facts of the particular case.
yes, exactly.
But that's the problem which these cases are focusing on.
Well, it is, and I've thought a great deal about that, my lord. Because that's where the plaintiffs put it. They say, if it's impossible, then this applies. But all that it amounts to doing is just shifting the focus and shifting the uncertainty onto the wrongdoer. And that's a policy and a moral decision. Should the doctors be in that position? Because what is scientific impossibility except uncertainty? You don't know. And you don't know because there isn't the evidence. And the orthodox...
And if there are two tortfeasors, suppose there's no innocent,
Yes.
suppose there's nobody who's innocent, everybody's guilty.
Yes.
But you don't know what contribution has been made by either.
Yes. Well, that's...
Unless you can establish the but-for test against both, you can't recover against either of them, can you? Or can you? You
well,
can.
that's the problem. But
Under the laws and standards at the moment, you can. You can recover the whole from either, leaving it
Them to contribute to.
them
Yes.
contribute between themselves. And that's pure policy decision. But why isn't that the same in relation to innocent dust?
because...
Tortfeasor pays.
Well, if that's what the board decides it should be, well then...
But that's the way it works if there happen to be two tortfeasors.
Yes, but then that's different.
Where one...
Because you...
Well, it isn't in relation to any particular tortfeasor.
Well-
Because a particular tortfeasor can run all the lines you're running.
well, with...
And the other tortfeasor can do that as well.
Yes.
So each can say advance exactly your argument today. And why can't they?
Well...
And which is the case that says
Yes,
they can't?
the reason why they can't, my lord, with respect, is because the person in the forest was entirely fit and healthy until shot by somebody. The person who goes into the emergency department is by definition sick. And the sicker they are, the more vulnerable they are, and the more likely it is that something, a minor bit of delay or a really de minimis, inappropriate phrase I accept, but some trivial period of delay or something is done incorrectly, but actually wouldn't have made any difference at all, but nobody can prove it. And the doctor's in no better a position to prove it than the patient, because that's the nature of the human condition. And so the question is, why should scientific uncertainty make a difference to that? You see, it's very different in the two.
But why doesn't that same argument apply in the two tortfeasor?
Because in the two tortfeasors case, you know that the person would have been uninjured, but for the intervention of two other agents, one or other of two agents. And in the natural causes, you do not know that.
But we're on causation. I mean, I absolutely understand that there may be, if you were starting in Olympian fashion, in simply framing a policy rule, there might be a difference between cases where you've got two tortfeasors and cases where you've only got one, and the alternative, the other cause is natural. But we're on the meaning of cause. Why does that differ as between the natural cause and one tortfeasor and the two tortfeasors?
Well, perhaps this is where Professor Stapleton's analysis really does come in, and she would agree with my lord and would say, absolutely, you describe it as a factual cause, but then she would say you get no damages for it because you haven't made a difference. You haven't contributed to the outcome.
I'm sorry, you're a factual cause, but you haven't caused anything.
Well, in the Bonings,
You thought you couldn't be a factual cause unless you...
well, I confess.
Anyway, all right, I'm following.
Yes, I confess that
I don't follow.
tend to agree with Lord Hoffman that it adds a layer of linguistic complexity and doesn't really help. But nevertheless, that's what she does. So she would describe, for example, the lightning bolt in the...
So do we have her in the bundle?
Yes, we do.
Yes. That's a joy that awaits, my lord. So she would say, well, the weakness in Bailey was part of the factual history and background. Yes, it was. But did it make a difference? Did it contribute materially to the outcome, to the injury, is the question. That's the legal question. And the scientific impossibility point, my lord, is very, as I say, I've thought a lot about this, not least because Lord Justice Waller in Bailey refers to it, and the litigation authority refer to it.
And Lady Justice Smith signed up to Lord Justice Waller's judgment, did she?
Yes, the others agreed with it. Yeah. But in McGee and in Bonington, you did not have scientific uncertainty. It wasn't a feature. The only uncertainty was as to, in Bonington, was as to apportionment, and in McGee, it was as to which exposure caused the dermatitis, but it was known that the dust caused the dermatitis, you just didn't know which bit of the dust. In Fairchild, the only uncertainty related to which defendant's fibre caused the damage, but there wasn't uncertainty about the mechanism. Now, how scientific impossibility is being applied here is to say, we'll apply it to the mechanism. We don't know how it was caused, and we'll give the plaintiff the benefit of the doubt.
McGee is a case, I think you just said, in which everybody knew that the dust caused the dermatitis.
Yes.
What they didn't know was which exposure it was, whether
Yes.
it's before or after he cycled home after not
Absolutely.
having had the shower.
Yes,
Yes?
absolutely. There was no issue but that it was the dust.
Well, there's no issue but that it's the sepsis here.
Well, there's the surgery as well, which is an unavoidable complication. I have no idea, because there is no data, on proportion of people who suffer intraoperative complications, what the morbidity is and so on. There's just no evidence at all about that.
But there was evidence in this case, was there not, medical evidence that the primary cause of the outcome of the surgery was the sepsis. And that has given rise in turn to paragraph 6 of the statement of facts and issues. During surgery, Mr. Williams developed complications caused by sepsis resulting from his ruptured appendix.
It was a combination, my lord, because obviously sepsis was part of the factual background.
Yes, but I think there was, am I right, that there was evidence, medical evidence led before the judge at first instance that the primary cause of the outcome was sepsis? That's my recollection.
Well, my recollection, and certainly my recollection of the judgment, was that it was a combination of the sepsis and the surgery.
What does that mean? Does that mean that
There
they were each caused it?
There were two factors, but then there always will be. But I accept.
Yes, but this was the removal of an appendix. That was the operation.
Yes.
Yes, which is usually a fairly uncomplicated operation, absent rupture and absent sepsis.
Well, that's an assumption, my lord, without there being.
Well, I mean, there may not be evidence, but I mean, isn't it?
Well, pre-rupture, yes.
Yes.
Post-rupture, I don't know.
You don't know.
Because there isn't. There is a paper in the bundle which I confess is in very small print, and I'm not sure that I can. Let's see if I can take.
Well,
It's the
fine. Yes, I'm sorry, I won't do that.
not at all. No.
Well, you've got the judge's finding of fact is that he's 113, I think you'll find. What he did was to accept Dr. Levick's opinion that the heart experienced a significant amount of stress caused by sepsis during the surgery. It's obviously,
Yes.
you've got to have the surgery as well.
Yes.
From this, I understand, the complications that he experienced were probably, which is the right
Yes.
standard, probably the result of a combination of surgery and sepsis.
Yes, absolutely. A combination of the two. I absolutely accept that. And I also accept...
So that each would satisfy the but-for test?
No.
Well, there wasn't the evidence and the...
No, but is that what the judge meant? Or what do you mean by probably? Presumably he meant that each would satisfy the but-for test. Because that's what probably means.
I also accept Dr. Zussman's evidence that sepsis is known to increase cardiac oxygen requirement,
Yes.
potentially precipitate myocardial ischemia.
Yes, so it contributed to the risk factor.
But that's a finding that the sepsis caused the complications, isn't it?
So never mind the law, you're stuck on the facts.
The law is what really needs sorting out.
Well, I follow that. But I don't think Mr. Williams would agree with that.
Well, I don't think he would, but happily, Mr. Williams personally won't be any worse off whatever happens. but not now. Of course, he would have been had we not delayed. Then he may have been better, but he may not. And this is one of the difficulties with this scientific uncertainty point. Going back to cancer cases, for example, you may have an 80% chance, but you may still die prematurely because you're in the 20% who do badly. You may have a 40% chance of long-term survival and survive, as Mr. Gregg did, probably. So we just don't know, and the issue is who, as it were, pays for that.
Are we still on your second of your four requirements for if it's an exception, these are the requirements?
We are, my lady, and the two others which are complicated are single agent and divisible/indivisible.
Yeah.
Divisible/indivisible is probably the one to look at first.
Inconvenient. Thanks. That's everything.
And, my lady, the paragraph references in our case are 12 to 14, 36 to 44. And the relevant citations to authority are set out there. I won't take the board to those because they're in the case. But the nature of the problem is this. Bonington was a divisible injury case. Bonington was a divisible injury case. That's how everyone interprets it now. And now, practice would be that the defendant would pay for that portion, probably estimated in the claimant's favour, but that portion of the injury which they'd really cause, proportionate recovery. If material contribution is not a but-for test, it means that if a defendant contributes anything more than negligibly to a process that results in an indivisible injury, then they are liable for the entirety of the injury, even though their contribution could not be said probably to have made any difference at all. And the difficulty arises in part from Lord Phillips's analysis of Shortell and Novartis Grimsby in Sienkiewicz. Both of those were cancer cases.
Isn't it possible to put, I imagine that it's not possible to put because this is not the way the law works, but the Fairchild-Sienkiewicz box is a box.
Yes.
So anything said in either Fairchild or Sienkiewicz has got no application outside the box. Wouldn't that be a feasible way of looking at things?
It's certainly said to be obiter, absolutely. And it was done in Jones, so yes. But then one is putting all of the analysis to one side and saying it doesn't really mean anything, which...
Well, it's because it's Fairchild is known to be an exception and therefore a box.
Yes.
What knockback effects there are.
Yes.
All the millions of analyses that there have been in all the cases since.
Yes.
Bonington,
Yes.
McGee,
Yes.
Wilshire Hodson, all of them.
Yes.
How much does that help us to actually work out what
Well,
the real law is?
Well, we respectfully submit that the real law is as applied in the Fernsite case by Mrs. Justice Swift and in Hennigan by Mr. Justice Jay, where they sweep aside these complications. They're both cancer cases. And
Where do we find those two cases?
Jones is in Volume 3, Tab 27, and it's an extraordinarily long judgment.
Yes.
And chapters 6 and 8 are the relevant one for the board's note. The reason I'm going to Volume 3 is because although an extract from 6 is in the core bundle, chapter 8 isn't. And so I didn't want to take the board to two different places.
1, 2, 2, 3. But I don't know where chapter 6 is, I'd have to...
Chapter 6 is no internal page numberings, but it's slightly less than halfway through.
Well, if you want us to look at it... Do you want us to look at it now or just make a note?
I would be grateful if the board could look at it at a later stage, because chapters 6 and 8 are long, but they set out a relevant... 6 sets out the relevant history of what is the appropriate test for legal causation. And so 6.7 to 9 deals with Bailey. 6.15 recites the warning about extension of Fairchild. 6.23 to 4 discusses the complicating feature of the cancer case of Shortell. Where the judge had applied doubling the risk, Lord Phillips said that wasn't necessary, applied Bonington, and both Mrs. Justice Swift and Mr. Justice Jay themselves go back to doubling of the risk. The balance of probabilities, not material contribution. That's the point. 6.23 to 24, she discusses Shortell. 6.25 to 8, Novartis Grimsby, a bladder cancer case. At 6.36 to 7, she identifies the explicit conflict between the atomic veterans in the Court of Appeal and the analysis of Lord Phillips and Sienkiewicz, and says she can't reconcile them, so then she goes on to try and analyse causation in that case by reference to all of the tests. And her findings are at chapter 8, paragraph 8.37 onwards. And if I can read from 8.48.
Sorry, page again, please.
My internal... Sorry, it's page 880 on the paper copy.
None of this is of any use to me. You know, the whole point about having this is that you type in a number and up comes the thing to which you're referring. If I have to find it from the index and I then have to trawl through many, many pages...
I can't apologise enough,
this is
my
just
lady.
unacceptable, I'm afraid.
I'm extremely sorry.
I don't normally lose my temper, but I'm getting very close to
I
it.
completely understand that.
Anyway, I think I've got to 1377, which is paragraph 848. Is that the one you want to?
Yes, please.
Thank you.
Yes. Mr. Walker, who was acting for the defendant, said that if the court was to accept the claimant's submission on causations, the result will be that in every case where a claimant was able to establish tortious exposure to a carcinogen greater than de minimis and had developed cancer, he would be able to establish causation. He'd be able to do so even when the carcinogen was shown statistically to have increased the risk of developing cancer by only a small amount. That, we say, in a nutshell, is the problem with material contribution to injury in an indivisible case.
But I'm sorry to keep going back to the facts of this case. I'm not sure that's what that maps on to the evidence or the findings in this case. A question was raised a moment ago, what was the expert evidence? And I've been looking again at the record, page 233. Dr. Lightman says, standard of care wasn't met, 2.3. Why? Delay in performing, interpreting and reporting the CAT scan was excessive, and that led to delay in necessary treatment, which resulted in the complications, as we discussed, with the heart and the lung, and the critical illness that developed thereafter. And there's put to him a passage in an academic article saying that the complications in this type of surgery are likely to be increased with passage of time, and he agrees with that. Now, in a sense, what more could he say? Isn't that a reasoned and sufficient foundation for the court to conclude that there was a material contribution to the ultimate outcome, as you put it? And if that's not sufficient, then what could be done in a world where, as you say, it would not be ethically permissible to take a cohort of patients, treat some and not treat the others, in order to measure the outcomes?
Yes. Well, my Lord, I'm not sure that I interpret that evidence as anything more than saying it contributed to the risk.
Well, it led to, he says, delay in treatment, which resulted in the complications. And, well, I'm merely repeating what's there on the page.
Yes, but of course, it's because it wasn't adequately explored that we're in part in the problem that we are.
Well, who's to blame for that?
Well, I'm sorry to say that it should have been explored adequately by both sides at the trial. The question is now whether it can be put right by drawing the kind of broad brush inferences without there being a proper evidential basis for it. And our submission to that is it cannot, because that would be simply papering over uncertainty. There isn't the data. I completely accept that septic load would have been increased and that septic load would have influenced cardiac requirements. I accept all of that. What I don't accept, because there's no evidence upon which it can be based, is that post-rupture, one can show that this kind of time period makes any difference at all to pre-rupture. Pre-rupture I absolutely accept. But, my lords, if this is an unsatisfactory factual basis, and if it needs to go back to Bermuda, well, it needs to go back to Bermuda. But it needs to go back with some clear law. In our respectful submission, it's not appropriate just to draw the kind of broad factual inferences that were drawn in things like Drake and Harbour, which is a completely different kind of context.
Why do you draw the line at the moment when rupture commences?
Because
You present that as a sort of light switch moment, on off, before they can succeed, after they can't. I mean, the assessment of when the perforation began itself is a somewhat uncertain science, isn't it? Because
yes.
It's being judged from clinical
Yes.
symptoms.
Yes.
But, and it then develops.
yes,
So at what point in that sequence do you say, as a matter of law, it is recoverable, but at this particular point ceases to be recoverable?
well, the question of law is, can the plaintiff prove that the delay, however long that is, on the facts, has caused the injury? That's the question of law. On the facts, one is, in some circumstances, entitled to draw inferences. In my submission, the reason for selecting the rupture as a significant point is because it is likely that there will be data relating to complications of appendicectomy, pre-rupture or post-rupture, but not otherwise.
The difficulty is, looking now at the transcript, page 119, the witness, Dr. Lightman again, says the rupture of the appendix is not like a bomb blast or a balloon burst.
Yes.
It's a progressive thing that occurs.
Yes.
He says you can see some clinical signs of perforation at 4:43, so the procedure had started.
Yes, I accept that.
I find it quite difficult from a practical point of view to say, well, what? I mean, the consultant, as we can see, has expressed his own opinion that the overall delay was instrumental in
Yes.
producing these consequences. But you say, yes, if it was before that process began. But what if the process had begun by 5 minutes in a minuscule amount?
Well, then we're into this causal uncertainty, and the question is gets the benefit of that doubt. In my submission, Tahir and Gregg and Scott are good law. They both say in delay cases, you have to prove the delay caused a measurable difference.
Yeah.
I do accept that in some circumstances you can draw an inference, but you have to be able to do that on the basis of adequate evidence, and there isn't adequate evidence here, because in my submission the only likely adequate evidence would relate to complications pre or post rupture, simpliciter. But we don't know because it wasn't explored.
So the difference is, you say that whereas the inference that the rupture caused, the inference that the rupture made a difference is a legitimate one.
Yes.
The inference that the additional sepsis did is not.
Absolutely. Thank you, my lord.
Well, it's all very well stated. I'm just trying to see why.
Because it is likely, we don't know because there wasn't the data, but it is likely that the only morbidity data would relate to rupture. Rupture as being a complicating feature of surgery. That's
just guessing at what other evidence might have been. I think you've just agreed with me that on the facts of this case, the judge would have been entitled to say, I infer that the rupture made a difference. Without any fancy morbidity evidence.
Absolutely, because that's, as it were, a matter of clinical common sense if you have an intact. Yes.
But increased sepsis is not.
No, my lord, because you don't know whether it's an analogue relationship or an exponential one. You simply don't know. There's just no data.
Yes, I mean your point is simply that no one can say whether the septic load was sufficient at the point that the innocent delay ended to have created the damage.
Exactly. Now, the absence of evidence is not the same as material contribution to risk. It's not the same as scientific uncertainty. We don't know what the evidence could or might have been because it wasn't gathered.
So what's defective about the opinion of Mr. Lightman in his report at page 414?
Thank you.
I think there's a later one as well. Or 414 in the old-fashioned numbering.
Which of these varies?
The one that says,
Well, if it's the bottom of the...
bundle of expert evidence of the trust. So 411 at the front.
And the pages.
414. So that's the one I was correct.
If it's the bottom of page 507, had prompt appendectomy been performed within 2 to 4 hours of the presentation? Is that the passage my lord is referring
It was
to?
actually page 414 in the...
That is the passage there.
It's the same passage.
Yes, same
Oh, it's the same
yes,
passage, I beg your
yes. So 2 to 4 hours presentation, reasonable degree of... Yes, well, I wouldn't disagree with that because that would have been before the rupture. And that was
Well,
their
that's what he's
case.
saying. Yes, if it had
Yes.
been done within 2 to 4 hours,
Yes.
it would have been pre-perforation,
Absolutely.
and he'd have been as right as rain.
Absolutely. And indeed, that was their case. That was the whole case they ran, and that's perhaps why none of this evidence was gathered, because the plaintiff's case was, I would have been, or should have been, in surgery before it ruptured. The defendant's case was, it had already ruptured before you got to the emergency department. So those two completely contrasting cases were utterly different in causation. But it's frequently the case that what happens at trial is rather different to what you plan for. But nevertheless, we are where we are. All we submit is that it's not legitimate now, given where we are, to get the broad brush out and paint it, this uncertainty with thick paint. So, but I do accept that if the board is not willing to recognise and respect the findings of the trial judge, then it has to go back to Bermuda. The final, because at the divisible-indivisible point, I hope I've sufficiently covered in the sense that there's no problems to having material contribution to a divisible injury. You get proportionate recovery.
Because then you can apportion.
Exactly. You get
And if it's indivisible, the reason why it won't work is pure policy.
Yes, it doesn't. Yes, because it's unfair to be paying for mass apportion when you can't show but for. Yes, absolutely. The psychiatric injury cases I know are referred to in the papers. I accept that if those are necessary causes, i.e. but-for causes, then there is no difficulty to recovering for the psychiatric injury. You measure the quantum by reference to all of the other features and what might have happened in any event, the vulnerabilities and so on. But you have the same difficulty with psychiatric injury if you allow a material contribution to a psychiatric injury and a material contribution is not but for, then you're in the same problem as in the cancer cases.
Actually, thinking about it, you are perhaps able to say, are you, that in the case of divisible injuries, there is no occasion for any exception to the but-for test, because you can apply the but-for principle to the divided section of the total injury.
Absolutely.
Yeah.
The only respect in which material contribution might be an exception is in the limited context of allowing full recovery where the defendant doesn't take the apportionment point, even though you know that the defendant is not responsible for all of the injury. So that is the only respect in which it might be a, as it were, permissible exception in those limited circumstances. Because if a defendant doesn't take the point, well, it's the defendant's own problem. The divisible-indivisible difficulties slip completely away if you apply but-for. Single causal agent the litigation authority suggests single causal mechanism, and I wouldn't disagree with that as a refinement. What you do need to do is establish with precision what. Sorry, my lady, it's page 8, paragraph 15 of their written case.
Oh, the interveners.
Yes, of the interveners. They suggest this as a condition of the exception, if such it be. Single causal mechanism. So the point here, my lords, in Fairchild, obviously, and the Fairchild enclave, there was only one causal agent relevant. There was only one causal agent relevant in Bonington and also in McGee. It was silica dust in Bonington, dust in McGee. The reason we suggest it as a limit is that if you don't have a single causal mechanism, you're in a Wilshire position. And both sides admit that Wilshire remains good law. So unless you can show with precision and prove what the causal mechanism actually is, and that the breach has materially contributed to that, then it shouldn't apply. I've suggested the case of ST at first instance as an example of how it ought to work. There's no need to go to it, but for the reference, it's volume 5, and I have it at paragraphs 215 and 216.
What's the tab number?
The tab number is...
50.
Thank you very much.
Sorry, I missed that. What number?
550, volume 5, tab 50.
Thank you.
ST is 50, yes.
And it's at 1702, page 1702, hard
Yeah,
copy.
thank you very much, my lord.
This is the passage that it may well be that a significant number of strokes.
Yes, exactly. It's yes.
I'm sorry, which paragraph?
215.
Oh, right. No, not.
It's not.
It's the last page of the
Yes.
It's the last page of the judgment. Yeah. Okay.
last, second last.
Get to it. Backwards.
The previous case.
2553.
Yes. So it may well be that a significant number of strokes occur as a result of a combination rather than a single cause. That fact alone doesn't assist me when determining whether the specific conditions from which the claimant was suffering caused by the defendant's breaches of duty, in particular delay, made a material contribution to his injuries. I have to examine the evidence relating conditions, ascertain whether we established to the required standard that they had a contributory role. And the breach of duty, the claimants had said, increased dehydration created a prothrombotic state, which would have made thrombosis more likely. He suffered stroke, cerebral stroke, and serious brain injury, and the claimant said, well, we have proved enough to establish material contribution because we've shown that you've created a risk factor, dehydration. But in fact, the judge examined the evidence and said that the strokes resulted from a different pathological mechanism to which dehydration may or may not have been, well, it was a background factor, but she couldn't show on a balance that it was relevant to the actual cause of stroke, and therefore the claim failed. In our submission, this illustrates the difficulty of going for anything other than a single causal mechanism. So, in that case, the claimant had to prove that the dehydration actually contributed to the stroke. And they were, even though they showed that it could have done, they didn't show that it had done, because the stroke was the result of a vascular deficit and a minor infection. And this is paragraphs 202.
So is Mrs. Justice Swift being consistent?
Completely consistent, we respectfully
I would
suggest.
expect that.
So would we. So would we. And so what the claimants are tantamount to asserting in this case is that as long as they can, well, they say we increase the specific risk, that's enough. But if you go outside of single agent or single causal mechanism as a limiting factor, then all you're doing is contributing a risk factor that you can't show has actually made any difference. And that's why we submit, if it's an exception. That's why it needs to be an exception.
Does Mrs. Justice Swift analyse it in terms of increased risk, or does she simply say, as far as I can see, she can't show that it made any difference?
She did find on a balance that it hadn't done, but she acknowledged that it would have given rise to risks.
Yeah.
So it created risk, but it didn't create a risk that was relevant.
Quite.
But the point is, my lord, that what we submit is that if you're going to have it as an exception to but-for causation, material contribution, you need to have a limit that a single causal mechanism applies, and that the contribution is to that mechanism, is to that pathology. Because otherwise, all you do is contribute a different, non-relevant risk, as was the case in Wiltshire.
Sorry, I ought to remember. Which one is Wiltshire?
Wiltshire was the retrolental fibroplasia, the young child with blindness, and a number of different causes of oxygen.
Thank you very much.
Well, it's the premature baby who's given
Yes.
too much oxygen.
Too much oxygen because they put the catheter in the vein rather than the artery. Yes. Because the interveners are not here, and I'm conscious of time, I wonder if I might turn to policy, because that is a...
Haven't you said enough about policy?
Well, the board may feel that
Well, you keep on saying it's unfair and you shouldn't do this and you shouldn't do that. And you're turning the doctors into insurers and all of those things. You've said
Yes.
that through. So is there anything more you need
Well,
to say about policy?
If my lady will give me a moment, I'll see whether there is. There is material in the interveners relating to value. And that's at their paragraph 39. 1.1 billion spend last year, 1.4 projected this year.
Of course, we're not deciding the role of England and Wales. You realise that.
Of course not.
That's
Mary,
one
but-
reason for not allowing the interveners to be here in person.
Yes, no, but this does have ramifications throughout. Not whether it's binding or not, the reasoning and the analysis will be of central importance to parties in clinical cases throughout the world.
Yeah.
The reason for picking up the point about value, twofold. One is that cerebral palsy claims now run at 10 to 15 million per claim. And the other is that in Snell and Farrell, which the plaintiffs rely upon, the Canadian case, there is a passage, I will get the correct reference because I've got 2420 in the paper bundle. I'll get the correct one. They refer to the effect in the States of loosening of the causation test, 500% increase in premiums and insurers going out of it, etc., etc. So in terms of policy, there is a very substantial economic impact in loosening the test, a very substantial one. And that has, of course, the Supreme Court post-Fairchild perhaps ruse the extension that was made in Fairchild and some of the difficulties that that's got the courts into. Now, one of the problems in this area is the same, because there was talk in the cases about, well, perhaps Parliament should have intervened. This is a similar area, because if a claimant succeeds in full, then of course they get their compensation. No one begrudges them that. And they are entitled to have a different standard of care than people who are dependent upon the public purse. People who only recover a proportion can't then have the same level of care, and they have to mix and match. So it's a burden on the public purse one way or the other, either via the state or via, in this country, the litigation authority picking up the bill.
How is healthcare financed in Bermuda?
Private insurance is my understanding. Yes.
Because obviously the arguments are
No, of course they are.
different as between
Well,
the NHS and various forms of private funding.
Well, they are, of course, and that's why the Snell and Farrell point is relevant. Of course, insurers will have assessed risk on the basis of the law as they understood it to be. And so it will have a significant impact there as well.
No, all I'm suggesting is that if you want us to take into account the economic consequences, financial impact and whatever, it's got to be those in Bermuda and not those in the UK.
No, absolutely, but the point translates even if the values don't. And the point is that high value claims are exactly that, very high value. And so the consequence of a loose test will have very substantial economic impact wherever in the world it is. I'm told that public funds in Bermuda actually do top up, so there is some contribution from public funds.
But you're saying, in effect, whichever the risk spreading mechanism,
Yes, absolutely.
high value claims
Yes.
increase
Well,
the sum that's got to be found somehow.
Well, they have a greater proportion.
that of course is true.
Yes.
The only point I was making is that if you want any judgment that the board arrives at to talk about this,
Yes.
we've got to talk about it in the Bermudan context and not in either the US or the English UK context.
Yes. Well, yes.
We don't, I think, have any information about that.
No, that is true, my lady, and I apologise for that. But there is it's private insurance, but with some public top up. But the economic effect is the same. However, whoever picks up the bill.
How many high value claims are there in Bermuda?
Whilst somebody is finding out that information, perhaps I can move on to another point, if I may.
Yes, of course.
Yes.
The big ones are the most injuries, presumably, are they? Mostly.
They are generally in this country brain damage. Yes.
The ones with very high care costs.
Yes. Yes.
In this country, but I mean,
Well,
I have a reason for asking because of the Guernsey case, the name of which is escaping me.
Hellman.
Yes, which is obviously all about the discount rate, but
Yes.
it's about a completely different point.
Yes.
But that is the only case with anything like that level of damages that they've ever had in Guernsey.
Yes. Well, certainly in
Yeah.
my understanding of the Commonwealth jurisdictions and the Canadian jurisdictions are that the cerebral palsy claims and the brain damage claims are extremely high value.
Well, yes, of course.
Because-
I'm just asking whether it goes on in Bermuda.
Well, I'm sure that it does.
Anyway,
but-
I will leave that. I'll
Yes.
park that
Thank you
question
very much.
with
Lily.
you.
I'll come back to that.
Now we have about another 5 minutes before we're going
Yes.
to adjourn.
Well, I'm grateful. I think I've already made the point about sicker the patient, the more likely they are to be vulnerable to risk. But all medical treatment carries risks. There is no drug without a side effect. There is no treatment without a risk. So if you are transferring on to the doctors, in effect, the burden of disproving causation, you're doing so in a context where what they have to do inherently is risky. If I may, mopping up another point which is made by the intervener about material contribution injury, they say it should not apply to single incidents, and it's there paragraphs 6 to 7.
Yeah.
They say it should not apply in single incident episodes. So it's a process test, not a single incident test. And they base that on the case of Clough, which is not in the bundle but is referred to in their footnotes. But Clough was the swimming pool case where a holiday maker fell into a pool and suffered a spinal injury, I recall. And the pool did not have non-slip paint around the edge of it. And he claimed that, had it done, he wouldn't have slipped. And material contribution was run as an alternative. And in the Court of Appeal said, no, material contribution injury doesn't apply in that kind of case. You have to decide it on but for. And it would be strange if that was the case in regular personal injury cases, but not in the clinical context. I wonder whether that, in fact, might be
Is that a convenient moment at which to pause? Well, yes, that would be helpful.
Thank you very much.
Thank you. Well, we'll look forward to hearing from you further at 2:15.
Not for very long.
Well, that will depend upon how much distraction you get, I think. Board is now adjourned.